Good evening, everyone. My name is Leoncio Rodriguez. I'm here to present your CPD, and thank you for joining us. This is an OPA CPD series. It's a panel discussion on advocacy, an OPA and Trials College presentation featuring the Law Society's Treasurer Ontario, and our president of OPA, George Brown, and esteemed panelists. Again, I'm the vice chair of the student committee at OPA, and I'm a student at Trials College in the Paralegal program. I'll be your host, and we'll be observing 2 minutes and 15 seconds of silence to remember and honor the lives of 215 children lost in the residential schools in British Columbia. The 2 minutes and 50 seconds start now. At this time, I would like to introduce Paola Lopez, our OPA and a student member, to invoke the Indigenous land recognition. Thank you, Paola. Please take away.
We are hosting this CPD webinar for you from the Waterloo region. We would like to acknowledge that Kitchener is located on the traditional territory of the Mississaugas of the Credit First Nation. We thank the First Nations people who lived and live in these lands for sharing them with us in peace.
Before we begin, we would like to start with some housekeeping. We'll present the pre-registered questions to the panel in the final segment of this evening's CPD presentation. I will also ask that you please kindly take a few minutes following this evening's presentation to complete the OPA Student Committee's post-CPD survey. Your feedback helps the OPA Student Committee improves their practices and delivering valuable services to our membership. Following tonight's live presentation, we will also provide additional resources for the CPD on our Learning and Professional Development portal at opau.ca. I will now introduce our OPA Secretary and our OPA Student Committee Founder, Scott Kennelly, and our OPA Student Director, James Dondo. Thank you for joining us this evening, and tell us more about your commitment to students, the membership, and the OPA.
Thank you very much, Leo, on behalf of James and myself. So the OPA committee believes that it's important to hear the stories of Ontario's very own legal professionals who can share their personal advice as well as legal resources for all paralegal students and new licensees. Tonight's event will be an informative session, and it's the very first CPD presented by the OPA Student Committee. This panel discussion on advocacy is the start of many planned future OPA Student Committee initiatives. The OPA Student Committee is committed to developing educational resources to enhance students' knowledge and understanding of the legal field, while also providing an opportunity to build great connections to network for the future. The OPA Student Committee's mandate is to engage dialogue and further promote education between experienced paralegals, students, and new licensees. For further information on the OPA and/or the Student Committee, please visit opaonline.ca or email me or James, the Student Director. You will find our contact information posted in the post-CPD resources. At this time, I'd also like to offer a very serious thank you to all of our panelists for all of their support in the creation of tonight's event.
This evening's CPD's moderator will be James Dondo. We have our chair of the student committee, Roxana Sol, to introduce our panelists. In addition, we have the members of the student committee at OPA, Secretary Jasmine Tutt, and committee members Paola Lopez, Kelisa Reyes, and Rochelle Esteban. I may please ask Roxana if you would like to introduce our panelists, please.
Thank you, Leo. I'll be honored to. I will now introduce the distinguished panelists who are joining us this evening. First, I would like to introduce Treasurer Donnelly. Teresa Donnelly is the Treasurer of the Law Society of Ontario, making her the top elected official of the regulatory body. She is the fifth woman to occupy the Treasurer position in the 224-year history of the Law Society of Ontario. Teresa Donnelly has been a prosecutor with the Ministry of Attorney General for 26 years. While she has prosecuted a variety of different offenses, most of her time was spent on domestic and sexual violence prosecutions and helping to ensure that victims have access to justice. Teresa Donnelly was elected as a bencher in 2015 and 2019 and has served on numerous committees and task forces. She is currently a member of the Federation of Law Societies of Canada, National Criminal Law Program. And a fun fact about Teresa, she is one of 10 children and she has 4 brothers, all of whom are lawyers. Also joining us tonight is Mr. Robert Bird. Robert Bird is a licensed paralegal with over 25 years of experience. He is the president of Not Guilty Plea, a law firm that focuses on municipal law, provincial offenses, and summary convictions. Robert is a founding member and past president of the Ontario Paralegal Association. As a 12-year bencher of the Law Society of Ontario, Robert is the chair of the Paralegal Standing Committee. Robert works to better the paralegal profession, welcoming questions and concerns regarding paralegal regulation to remain informed and ready to effect positive change. A fun fact about Robert, he has performed at many community theater presentations and has melded his love of performing with his love of helping people into his paralegal practice. We are also joined by Mr. George Brown. George Brown is a licensed paralegal with over 20 years of experience. He is the president of the Ontario Paralegal Association. In addition to this, he owns his own paralegal firm, the George Brown Professional Corporation. George Brown's expertise includes small claims court, landlord and tenant tribunal, condominium law, provincial offenses, and human rights. George champions access to justice for the paralegal profession in providing competent education from within the framework of the Ontario Paralegal Association. A fun fact about George, he has a passion for music and has DJ'd in New York City and Toronto. We are also joined by Mr. Edward Claxton, also known as Ted. Ted Claxton has been a lawyer for over 40 years. A graduate of the University of Ottawa, his primary practice areas include criminal law, family law, and personal injury litigation. He has been a legal educator for many years. Currently, he is an instructor and program coordinator for the Law Clerk and Paralegal program at Trials College, for the Southwest Ontario region. He has published works in journals such as the Osgoode Hall Law Journal, and most recently, he worked on Justice Ed Salhani's Practical Guide to Criminal Evidence as an editor. Ted Claxton gives back to his community as a member of the Board of Directors for the Lake Superior Watershed Conservancy and has acted as a leader for 25 years at Scouts Canada. A fun fact about Ted, he was the gun sergeant of Gun 4 of No. 1 Battery, 30th Field Regiment, Royal Canadian Artillery at the Centennial Gun Salute of July 1st, 1967. He was also the one who fired the 100th Artillery Salute. Also joining us is Ms. Stephanie Krug. Stephanie Krug is a criminal defense lawyer with over 25 years of experience. Throughout her career, she has handled many high-profile criminal cases serving the region of Waterloo in Wellington County. She is one of the first 3 women to practice criminal law in the region. Additionally, she is a member of the Waterloo Region Law Association. She focuses on challenging racialized communities and youth in the community. She is a director of the Waterloo Region Boxing Academy. Stephanie Krug is a graduate of the University of Ottawa Law School. Stephanie Krug is regularly invited by media stations such as CTV News and CBC News to comment on criminal law matters. We are also joined by Ms. Naomi Sears. Naomi Sears is a lawyer who has been praised for being a changemaker in the profession. She is a registered member of the Canadian Council for Aboriginal Business. Her areas of expertise includes Indigenous, administrative, environmental, energy, mining, criminal, and corporate law. Naomi Sears has experience working with government entities and corporate clients. She is an adjunct professor at the University of Ottawa. Naomi Sears currently runs a modern and competitive digital practice. She serves clients in both Alberta and Ontario and is frequently invited by the media to comment on pressing issues and issues of national importance or public interest. A fun fact about Naomi is that she has her possession and acquisition license for restricted and unrestricted firearms. She could also start a fire without any matches or a lighter. I will now ask Leo to take over for the Q&A portion.
Thank you, Roxana. We'll now move to the question and answer portion of the CPD, moderated by James Dondo. James, please take away.
Good evening, everybody. Welcome to our CPD and welcome to our honored guests. I'm going to be asking some questions and getting some feedback, and hopefully we'll all learn a lot tonight. I think these people have a lot to offer. So I'm going to be asking questions, and I'm going to have a couple of specific people that I'm going to direct the questions at and then open it up and see what happens and see what kind of responses we can get. The idea is to get some interaction so that we can all benefit from the wealth of knowledge that's sitting in the panel here today. The first question I'm going to ask tonight is, what do you see as the differences between tribunal advocacy and advocacy in a criminal or quasi-criminal setting, and what should students realize about these differences? I'll toss it over to you, George.
Hi. Can you hear me?
We can hear you fine.
Oh, okay, good. So I don't do a lot of quasi-criminal work, but and I would probably let Robert Bird answer that portion of the question, but I'll just give it my limited knowledge. One of the big differences that I see is the tribunal received most of its jurisdiction from statute, and its process is not as formal as the quasi-criminal process. The evidence or the finding is based on the balance of probability, while the quasi-criminal, I think it rises to the level of beyond reasonable doubt. Insofar as the findings, the penalty in the criminal, quasi-criminal can be heavy. In terms of the tribunal, no one will go to prison unless there's a contempt, and the contempt is serious enough that an adjudicator orders a contempt. And in all my years, I haven't seen that happen, so it's very rare. So in terms of the tribunal is much loose in terms of evidence and disclosure. Evidence is weighed on whether or not it's relevant, and even though a licensee or a non-licensee may not file evidence at the appropriate time, it doesn't mean that evidence will be omitted. The member can make a discretion, exercise his or her discretion as to whether or not that evidence comes in. On the other side, a quasi-criminal, not disclosing certain information can be fatal to the case. And so those are just some of the differences that I see in terms of criminal and quasi-criminal. And I would ask Mr. Bird to add to that part of the quasi-criminal, as he's much more experienced than I am in that area.
Thank you, George. Again, I want to thank the committee, the student committee, for the invite. I really appreciate it. I'm excited to be here. So to start off, George is quite right that the main difference is the burden of proof. Obviously, when you're talking about administrative law, you're looking at the balance of probabilities. In criminal and quasi-criminal, which are very similar in nature and structure, it's proof beyond reasonable doubt. Some of the main differences as well is in tribunal work, you might be representing a member of the public versus another member of the public in a civil or landlord-tenant dispute, or sometimes against an employer. Whereas in criminal and quasi-criminal, it is you're representing a client that's charged by the state. So whether it's the municipality, the province, or the federal government. So in those situations, you're also going to be dealing with a prosecutor. A prosecutor obviously is trained, legally trained to provide legal services for their single employer, which would either be the city if it's a municipal prosecutor, the province if it's a provincial prosecutor, or the federal prosecutor. And so your skills as an advocate are critical in that you'll have that prosecutor who's well trained, and then you're going to have the enforcement agency, which is the police that have laid the charge. So as we all know, our advocacy skills are critical in these types of criminal and quasi-criminal matters, because the proof of reasonable doubt, you have to discredit the prosecution's version of the events while bolstering your client's version of the events as well. So there's a lot of those types of skills that you would need. Obviously, there are also civilian witnesses. Civilian witnesses could be independent witnesses, meaning people that have no direct connection to the matter and were just eyewitnesses to it. And you'll also have victims. And so your advocacy skills have to play different roles depending on who you're dealing with. And I've always said it's really important to know who your trier of fact is as well, because the judge or justice of the peace that you're in front of may dictate the approach that you take. Because you could take a very aggressive approach, say with a police officer, or a very calming approach when it is an independent witness, someone who's there just to give their civic duty. So a lot of it, important advocacy skills is knowing the players in the event. And so One of the things that I have learned during the course of time is the form of questions that I use. Sometimes you form a question where you lead the person down to the answer that you're looking for. And so that will come, that sort of advocacy skill will come with experience. The more you practice it, the better you will become. And I try to stay away from scripted questions. A lot of times I encounter a fairly new prosecutor who has all of their questions scripted, and I will try to make an objection as early as I can to sort of throw them off, because they're using that script to get through it and they're not really listening. So what's important about your advocacy skills in the criminal and quasi-criminal matter is, first of all, know what the answer is going to be, because you never want to ask a question that you don't know what the answer is to it. And more importantly, listen to what the answer is, because it may require a follow-up question depending on what the answer is. So those are the things that I think are different between what George stated in the administrative law, the tribunal world, versus the criminal and quasi-criminal. The proof beyond a reasonable doubt, the threshold is much higher for the state rather than the balance of probabilities. And so those would be, I think, the biggest differences I know. Naomi, is there anything that I've missed that you may want to add to that?
Sorry. I actually just did my first cross-examination over the summer in person. I have, since the start of COVID, done them over the phone or over video, which requires different skills and more targeted strategy. For me, I do write things down. I have it on a half sheet of paper. So the questions on one half, what I want, the information that I want, and then the answers on the other side, and something to come back to in a potential reply, because I'm anticipating what the Crown may do. One thing I recommend with any proceeding type like this is to develop checklists for yourself to understand what the legal test is, and to understand your role. It sounds kind of elementary, but I rely on checklists day in and day out, just to ensure that I'm on target, that I'm meeting my requirements in different kinds of files. And this is for criminal law, corporate, going to trial, going to a client meeting. It can help keep your clients' costs low as well, because your checklists are a tool, and then it also helps with auditing if you're ever audited by the Law Society, in terms of discharging your responsibilities as a competent legal professional under the rules of professional conduct.
All right, thank you, all three of you. That was a great start. Next question. What do you see are the differences between oral and written advocacy, and how can we better our skills as paralegals, like Naomi was referring to, checklists? Stephanie, do you have something for us?
Hi, everybody. Thanks for inviting me to join you. I find there's a big difference between oral skills and written skills, or written submissions and oral submissions. My preference is oral. Very much like what Naomi was saying, I will write down just about everything. You don't want to be over scripted, but you do want to be prepared. You want to be sure that you're not overlooking any of your points. Also, like Naomi, I divide my page. When it comes, though, to making some sort of oral argument as opposed to questioning your witnesses. The benefit for me in having everything written out first before I make the oral argument is I'm the type of learner, and we all know there are different types of learners, but I know that by writing everything out first, that very act of writing it out allows me to process the information and then allows me to better deliver my points. I can then, when I'm making the oral argument, know what I want to emphasize, be comprehensive in what I'm covering because I've got my notes in front of me, but I can also make eye contact with the judge because I'm not reading from script, but I am relying on something in writing in front of me. Oral argument, you really have to know your material, you have to know your message. The interesting thing about oral arguments is it's not uncommon for the judge to either interrupt as you're making the argument or save a bunch of questions for the end of the argument. And I actually appreciate that. And it's one of the primary reasons I prefer oral arguments over written arguments. When the judge is asking you questions, often they're showing you their hand. You get to see where either the shortcomings are in your argument, what the judge feels your obstacles are in convincing him or her to your side of the argument. But more so, it allows you to then go back and fill those holes. It allows you to address the judge's concerns in a very head-on fashion. You're not left with some feeling of mystery as to where the judge's head is at. So that's the real key benefit to oral argument, in my opinion, the interaction that often occurs in oral arguments. The other thing is, in an oral argument, as I said, I rely on notes, but my notes don't have to be grammatically perfect. They're point form. They show me my roadmap, but they don't have to be artfully written. When you write, in contrast, when you write an argument for a judge, which in my case in criminal court, you want to make sure that your punctuation, your spelling, your grammar, everything is absolutely perfect. Legal writing, as you probably know by this stage, is quite different from other forms of writing. You need to be factual, you need to be to the point, you need to be able to defend your arguments by making references to case law. And there are some brilliant legal writers out there. I don't know, I'm not sure I'm one of them, but I think the pressure of putting it all down on paper in a way that is compelling, convincing, reads well, and satisfies everything, is a one-shot deal. So unlike oral argument, where you can then have an exchange with the judge and sort of narrow in and hone in what your issues are, you have to put it all out there in your written argument. You better make sure it's good.
Thank you. Ms. Donnelly?
Thank you. So I agree with Stephanie. I just want to pick up on a few things about what she said. So when I was thinking about coming here and, getting ready and preparing, I typed in, what's the difference between oral argument and written advocacy? And the first article I read, the opening line was, easy reading is hard work. And that really it just really speaks about the difference between oral advocacy and written advocacy. So Stephanie talked about having notes and using those to launch your oral advocacy really as you're on your feet. Written advocacy takes far more time. It takes a lot of work to think through what facts are important, to think about how that applies, how the law applies to the facts, to distill it down, and then to write your arguments so that your arguments are compelling. They're short. I mean, you can't have 50 pages of written argument that are going on and on and on. You need to be thoughtful. You need to be concise. You need to be analytical. And that's what makes the written advocacy part a lot harder. And one of the things they talked about in written advocacy is point first writing. So state your point and then go on in the paragraph to talk to describe it or to finish it. Also, before you can write, you really have to understand everything about your case, the facts and the law. So you have to go in having done your research. Another is that you have to be succinct, because judges or adjudicators, they don't have time to be reading, as I said, 50 pages worth of documents. The other, and this goes for whether you're giving oral advocacy, oral argument, or written argument, is you have to be correct. So one of the things as an advocate that you want to build with the court is you want the court to respect you. You want to be seen as being reliable, and you want to be seen by the court as being credible. Exactly what you want your witnesses to be found. You as an advocate have to be that way, because if you do that and you demonstrate the knowledge of your case and the knowledge of the law, then the judge or the adjudicator knows that they can rely on you when they're asking a question. Maybe it's a question about procedure, about legal procedure, or maybe it's a question about substantive law, or maybe it's a question about the facts of your case. Well, if the judge or adjudicator asks you a question, like Stephanie says, and you're going to answer it, they want to know that they can rely on you, that what you're saying is correct or right. So it is really important to have that knowledge before you go in. So I think those are the things that I wanted to say, James, about oral and written advocacy.
Thank you. George, you got anything you want to add?
Sorry, I agree with both. I don't know her last name, but I'll refer to her as Stephanie as well. And the treasurer. Stephanie talked about her notes. I usually create a spreadsheet, 4 columns. I never use the first column. I don't know why I created, but I've left it there. The second column is usually my questions. The third column is usually what I expect the other party's case to be about, or some of the issues that they're going to raise. And in that column, I usually put in highlighted the name of the witness that I also pose this question to. And then my fourth column is always quick reference to my document brief or the other side's document brief. And I feel that this allows me to jump around the place, jump all over the place, and be confused into the other side, because I'm ready and I'm not going to confuse myself. And I feel comfortable with this process, and I've done it for so many years that if I were to walk into court without this kind of preparation, I'm not sure I'd feel confident. As Stephanie said, you want to make sure that you don't miss the points that you want to bring forward. And I feel that this kind of setup allows me to focus on the points that I want to bring across. There's nothing worse than ending the trial and walking away saying, why didn't I present that? Why didn't I present that? And so I will go over my questions maybe 2 or 3 times before the week of the trial, just to make sure that I've covered everything I want to cover. And then as I wander around, more things may come to me, and I may go back and amend it and go back to my document brief. But it's always good to be prepared. I mean, we always hear about those senior advocates who can pick up a file the day before and walk into court and just shine. I think to rely on that, it's a big mistake. One day, someone will be more prepared than you, and you will simply, fall on your face because you're not ready to deal with the other side and all of the things that they're going to throw at you. And if you are prepared and set up your questions and all of the different references that you want to go to, I find that, even if you're thrown, something comes at you that you're not prepared for, you're going to get your case in and be able to in the end, close it up and present well in front of the judge. You always want to present well in front of your client. And you're in a courtroom, which is a public forum. There's other people in there. You want to present well in front of them as well. And so there's nothing more embarrassing than someone who's not ready. And so I try not to be that person. Thank you.
All right, thank you, everybody. Great answers. Now, following along in that vein, I'm gonna start with Ted, and then go over to Stephanie, and then the rest of you. This top three things, top three tips. I know we touched on a few things, but is there anything that you got? Anybody can think of the top three things that would help us be better advocates generally?
Well, I've sort of revised the question a little bit, and I say, what are the top three tips to being an effective advocate? Anybody can get up and blab, but not everybody can get up and say things that somebody's actually going to take seriously. The first thing that you have to understand is that the law is an intellectual exercise. It starts up here. You need intellectual capacity, and this means applying critical thinking with everything from beginning to end. If you don't apply critical thinking, you're going to miss something. And when you miss something, I'm sure every one of the panelists here would say it, you know, you get blindsided, whack, just like that. And who wants that to happen to them? It requires looking at the situation from various angles to see what is the best way of doing it. It's going to help you decide your course of action, what you're going to do, by looking at the various options that might be applicable to the case. Next, language skills. Language skills are very important. You should write down this word, opprobrium. I ask my students about opprobrium. Not very many know what it means, but I use that word in a case. I said to the court, my client has suffered severely with the public opprobrium. I was trying to mitigate the sentence. In that one, opprobrium, of course, is the disgrace or scornful reproach incurred by conduct considered outrageously shameful, infamy, a cause or object of such disgrace. My client had been a person well known in the community, did something that was rather outrageous. It was in the paper, it was on the news, and the submission that I wanted to make to the court, of course, was that my client had already suffered severely because of this public disgrace that had fallen on him. I didn't care whether the judge knew the word opprobrium or not, because I told them just what it was, what I just read to you. But if you're not thinking about these different ideas, about the kind of words, the kind of way that you say something, you're not going to be convincing. And if you're not convincing, you're not an effective advocate. The next thing is discretion. If you want to be an effective advocate, you have to be able to deal with discretion. What is the right thing to do in a particular situation? I made it an absolute rule that I never talked to the press, TV, any reporter that came up. When they'd ask me something about the case, I would tell them, if you want to know what the case is about, you should come and sit in court and listen to what I have to say. And some of them would do that, and some of them, well, they had their deadlines and I didn't have anything to say, so that was the end of it. The next thing, and that comes along with this discretion, has to do with your reputation. Your reputation follows you everywhere at all times. I made a mistake once, and you shouldn't tell anybody this, that Ted Claxton made a mistake, but I'm telling you here in confidence, so to speak, even if this is a public forum. I was over in Guelph and I forgot about a motion that I had in the afternoon in Kitchener because our motion in Guelph went on and I didn't get finished until about 3 o'clock. And then I went back to the office instead. And I forgot to call the court in Kitchener to tell them what my problem was. So you can imagine what happened. The motion that I had got dismissed. So I asked the other lawyers, I told them what my problem was and what had happened, just as I've told you, and asked if they'd set it aside and I'd even pay their costs of the day for it. They said no. So I had to hire a lawyer, a competent one too, who brought a motion to have the motion, my motion, put back on. At that hearing, I was informed of this by my lawyer, I didn't go to the motion, that the lawyers on the other side started making some derogatory reference to me. And the judge, I was told, intervened and said, Mr. Claxton's bona fides are not in question here. The judge granted that and gave costs against the other side because they did not consent to that motion. So these things, understand the law as an intellectual process. Develop your skills in writing, in speaking, and develop your vocabulary. And thirdly, discretion and keeping your reputation in a high state. Because if you don't have a good reputation, you won't be believed by anybody.
Thank you, Ted. Stephanie?
Thank you. I agree with Ted's 3 tips, absolutely. I'll just add a few more. In the first one, you may scoff at me, but my first tip is spend as much time as you possibly can in whatever courtroom or hearing room that you anticipate doing much of your work. Courthouses are virtually closed right now, and you can't follow the advice I'm giving you, but this is the reason I'm saying it. 27 years ago, when I was a young lawyer, I would spend all day at the courthouse, and it was incredibly educational to watch the different styles of different lawyers, to watch the styles of different judges, to understand the process in a way that you cannot possibly understand simply from going to school or reading textbooks. And all of that helps a person, a young lawyer, a young paralegal, hone their own sense of style. And once you can develop that level of comfort on your own feet, other things just seem to fall into place. But it really, I believe, starts from watching and listening very carefully and learning. There are, I think, in 2021, so many different styles that a paralegal or a lawyer can adopt. I would say that when I was coming up, there weren't that many styles. The diversity didn't exist among the bar, and there was sort of a caricature of how lawyers were to act in courtrooms. Forget about all of that. Go watch, see how other lawyers do it, how other paralegals do it. Decide for yourself what would suit you and what fits for you, and that entire process will be really educational for you. Hopefully we'll all be back in those spaces very soon. My second tip is, and this has already been touched upon, but you must know your material inside out. Read every word of every document that you're provided. Read it multiple times. Spend a lot of time with your client. Take excessive notes when you're working with your client. Understand your client's position. Ask a million questions of your clients. And it's only through that process of having all of this material and knowing all of your material that you can develop a theory for your defense. So knowing your material inside out in the preparation, that leads to my third point, which is developing a theory. Sometimes it comes to you, sometimes it doesn't. Sometimes it's an aha moment when you finally are able to sort of piece together all of what you know and you believe the case to be about, or what you want to advance the case to be about, in a way that counters, in my case anyway, counters the Crown's theory head on and dismantles the Crown's theory. When I say theory, I mean a sense of cohesiveness of all of the information that you're working with in a way which advances your client's objective. Your theory is going to be typically very different from the other side's theory, and that's okay. Where there's overlap and elements are the same, that is okay too. But it feels so much better, so much more comfortable when you can walk into a trial and have this cohesive theory in your back pocket, because everything else will, I hate to sound glib about it, but everything else can sort of magically flow from that if you're prepared and you know your file inside out. So those would be my 3 tips. Watch other people in your profession, know your file, be prepared, and then try and use that preparation to develop a theory.
Excellent, thank you. Just open it up to everybody else on the panel. Just like 1 or 2 quick points that might have struck somebody that haven't been mentioned yet. George, I see you're unmuted, so why don't you just go ahead?
The one point I would add to that is being candid. And I know I was introduced as having been practicing for over 20 years, but it's a little bit longer than that. And the one thing I've learned over that period of time is being candid. And because of that, I've developed a reputation with my colleagues and the judge, whoever I appear in front of, that I will be candid about even matters that hurt me if I'm called upon. For example, I remember a time when a judge asked me a question, and I was tempted to give him the answer he wanted, or I thought he wanted, but I realized that wouldn't be candid. And so I asked for a break so that I can take some time. Can I have a 5-minute break so I can take some time and think about my answer? Because I'm about to put my reputation on the line, because if it's determined later on that I misled the court, I'm going to be in so much problems that I would need to sit down and think, why did you go and do that? So that 5-minute break gave me the time to put my candidness in order. When I came back in, I not only joked about the fact that I would have misled the court had I continued, and that's why I had to seek a 5-minute break, but I explained to the court and advised the court exactly what they wanted, answer the question. I could see opposing counsel on the other side was thinking, this is unbelievable, but this is what our profession is about. When your colleagues can trust you, even in a situation where what you're about to say, if asked, may hurt you, but it will preserve your integrity with the court, and it will preserve your reputation with the court, and it'll give you something that is lasting. And I certainly enjoy being candid with my colleagues and the court at all times. And that to me is an important thing to always have and remember.
Thanks, George. Robert, you look like you're ready to go.
Thanks, James. So, I can't argue with any of the points that have already been made. The one thing I would add is, there's two things I would add really is knowing the other side's version of events. I know Stephanie said know your own material so you can devise your own theory, but you should also do that for the opposing side. That way you can anticipate what's going to happen, because the best advocate is one that knows everything that's going to potentially come. You don't want to be caught off guard. It's never a good thing. And when you know the other side's version of the events, your questions are crafted in a way that can discredit their version while bolstering your own. The other thing is relax, calm, be calm, because the presentation actually goes a long way. If I am stuttering and I am unsure of what I'm saying, I'm nervous, if I'm twiddling my thumb, clicking my pen, things like that, believe it or not, are distracting. And you don't want the trier of fact to miss a key point because of your nervousness. So even practice rehearsing your opening and closing arguments. Look in the mirror and practice it. I know when I first started, I did that because I was a nervous wreck, but now it comes more naturally. But those are the two things I would really say: know the opposing side's material and practice your actual oral presentation.
Thanks, Robert. Teresa?
So thank you. I'm going to be very brief. 3 things that I'd ask you to think about in addition to what's already been said. One is never be afraid to ask questions. It's okay to ask the court for clarification for whatever they're asking you. Don't be afraid to do that. The second thing is you need to build connections. And why do I say that in the framework of advocacy? Because it provides you with support. So if you build your connections, whether that's being a member of a legal organization like the Ontario Paralegal Association, or a member of your local law association, or other organizations, it provides you with a community of support. So you're not alone, and you have someone to go to ask questions, to bounce things off, and I think that it helps to develop your skills. The third thing is to use the Law Society's resources. We have the Practice Management Helpline, which if you have a pressing ethical or practice management helpline question, you can call the helpline. We also have the Coach and Advisor Network. I know we're running out of time now on this question, and I also get to close the conference. So I'm going to use that time in closing to tell you a little bit more about the Coach Advisor Network. I'm not going to take that time now.
All right, thank you. Naomi, would you like to add 1 or 2 points real quick?
Yeah. One point is oftentimes in my practice, I have individuals who are not relatable to the decision maker. Sometimes I represent sex workers, and often like their realities are different. So I have to think of ways that make their facts or their situation relatable. So really sit down with your client and think about the use of analogies in their case. So just by way of example, in the WorkSafe case, in the motion for anonymization, I use the analogy in the oral argument of that this anonymization order is like seeing eyeglasses, and the seeing eyeglasses, you know, my clients can drive the car without them. Will it be safe for everybody else? Will it be safe for them? Likely no. And the anonymization order will allow my clients to proceed safely in the proceeding. So obviously when you're before a judge and other lawyers, they're mostly wearing glasses. So it was very relatable, and you know, it really got down to the matter. Their safety would be at risk if members of the public or the press were to publish their name and connect it to their stripper identity.
Excellent. Thank you for that, everybody. Next question I'm going to address to Ted. And where do you see paralegal advocacy at this point, and where do you think it will be most needed in the future?
That's a very tough question. I've been, since 2012 up till now, I've been teaching paralegals, and I think it's one of the questions that people are asking, like, where is this going? So one of the things that I feel is that the public is not yet aware, despite the fact that it's been about 14 years since paralegals have been in part of the legal process. The public still doesn't really understand who they are and what they're about. And there's a confusion between a licensed paralegal and people that the public see in a office that are called paralegals but are senior clerks or whatever. So that's one of the real problems that I see. Then the question is about where is it that paralegals could provide services? Well, one of the places that they could be is at the provincial offenses court and at the summary convictions courts, assisting with the legal aid practice that's there, that there are people that can act as consultants. At the moment, they're not really able to do that. And then what other areas of law? I think the treasurer has spoken about this aspect of things, and that is, and I think other members of the Paralegal Association as well, that there's too big of a concentration on a few areas of law, and that the broad scope, I don't know how many there are, but a couple of hundred different tribunals in Ontario, most of whom nobody has heard. And it's one of the things that I think in the educational aspect of this is that paralegals should be exposed to more of these opportunities that exist there. The other thing is this, that I think that given the abilities and qualities, one of my students had been a lawyer in a common law jurisdiction in another part of the world, came to Canada, but becoming a lawyer and going through all that has to be gone through to qualify, this person did not really have those resources, so turned to turn to being a paralegal. And, you know, there should be discretion available to lawyers to have paralegals attend on motions, because it's not a trial, and on a lot of these motions deal with evidentiary matters that are coming forward, or things that aren't being done quickly enough. All these kinds of motions, I think any paralegal is reasonably competent could do that. They're already, of course, in the Superior Court, basically, because the Small Claims Court is a division of the Superior Court. So I don't see any reason why paralegals could not do that kind of work. And it would free up lawyers to do things like interview clients and get their stories and acts together, as Stephanie was mentioning. So then the question of family law practice and some other things are coming up that we need to talk about.
Thanks, Ted. Sorry, George, what do you have thoughts on this?
I think the paralegal profession's come a long way from what it was prior to regulation. I think being regulated by the Law Society has given a lot of credibility to the paralegal profession. And we've seen over the years the education that paralegal students undertake before becoming paralegals. I think that has been tremendously helpful in building the competency in the profession. I know when I started, I was kind of being blindfolded and kind of knocking into things until I find my way. I see the students coming out and you know, a lot of them are ready to practice. A lot of their skills are honed and they're ready to go. And I think this can only get better with time when organizations such as the OPA and the Law Society and the Standing Committee work together to improve this. I know there's a lot of grumbling about education, but I think we have to take baby steps, and I think we will improve these you know, issues that we have over time. But in terms of what I see the students coming out. I can tell you they're much more prepared than when I started, and I can only, you know, dream of what it will be in the future. That we are on good track, good soundtrack, and the students here today. I just want you to know that the things that we're talking about, these will become skills that you will develop over time if you're serious about it. And I can tell you that I certainly look back on my 20 odd years, and I still love this profession or what I do. As you know, going back to the first day I started this, I did run into a really tough judge on my first day, Justice Campbell, and it made me go home and think about, why do you want to do this? I'm a Gemini, so I have these two people talking to each other all the time, and one of my guys just thinks you just lay low key, and the other guy goes out and do everything, and so they have this war going on from time to time. And on this particular time with Justice Thompson, one of my guys was saying, why do you have to put yourself in this situation? But that person has been silent, and I enjoy what I do, and I believe that that you will come out and join the ranks of the paralegal profession, and you will do great things. In terms of where I see the paralegal profession going, if we look at what has happened over 12 years, since regulation, someone correct me if I'm wrong about the 12, but we can only hope for good things. Working with the Law Society has been great, and we see more and more things being opened up in this profession, and I think the sky is the limit. And we need to earn this opportunity that we've been given, and support access to justice, and be competent, and represent people, the public in Ontario, to the best of our ability. And I can only see good things. Thank you.
Thanks, George. Good. Robert, your thoughts?
Yeah, so where I see paralegal advocacy right now is we are really focused on some specific areas of practice that we almost become like specialists in. But what's really keen about the moment and transition we're in right now is that we're moving to video conferencing. And I think the students that are listening on this call now, you are in the ideal situation where you're able to take modern practice of technology and traditional practice with advocacy skills and combine them together. Knowing how to operate Zoom and other video conferencing platforms like Teams, Microsoft Teams and so forth, Google Meet, you students are going to have, all learn while it's happening, where, the old guard, if we can call ourselves that, sorry, George and everybody else, but we're learning this right now. You guys are going to come out as, experts in it, and you're going to be able to utilize advocacy skills and technology and put them two together to be great. That's where I really see the future as far as paralegal advocacy, is combining oral skills and technology to create representation that's not only on the edge of technology, but also getting access on your fingertips to a multitude of resources that old school we didn't have. If you didn't have it in your briefcase when you came to a courtroom, you did without. Whereas now, more and more you're seeing less physical file folders and more laptops being brought to court, iPads being brought to court. And I think that's where advocacy is really going. It's going to be a hybrid between technology and advocacy skills. So that's where I see things. So those are my comments.
Excellent. Thank you. Thank you, everybody. Just a quick reminder before we carry on, for the people that are writing in the Q&A, we did request that questions be sent in before tonight's event. So I'm not certain that we're going to get to any questions that you've asked, but if you have questions, feel free to email anybody on the board. They'd be happy to get you an answer as we can. And Robert, while we've got your attention, how can we make the OPA and the LSO more relevant to students?
So this is, to me, one of the most important questions that we're being asked tonight. And I'll explain why. I think it's more important now than ever that legal organizations like the Ontario Paralegal Association need to step up and provide true leadership when it comes to students and new licensees. With COVID, student placement and mentorship is becoming more and more difficult to land. And as such, students and new licensees are really missing out on a lot of the networking and socializing that would have happened in the courtroom or at OPA events. So legal organizations, in my mind, like the Law Society and like the Ontario Paralegal Association, really need to expand their networking and their CPD events that they do over video conferencing platforms to allow more Q&A. Just as you said that, James, now I'm saying that we should have more Q&A so that students are afforded an opportunity to ask questions and have, for example, students on boards so we can have insight. I know the Law Society, for example, we last year had a motion at our annual general meeting from the Law Students Society of Ontario, where they were requesting, you know, to be at the table, to be part of the decision-making process. And I think that's extremely critical. As we all know, to mention the Law Society, they're doing a great job trying to connect students through social media, our website, various different CPD events, such as the one here today. And also the treasurer herself has done countless hours of attending virtually every accredited college program to talk to students and as they prepare for their career in this paralegal profession. I too have spoken to several classes of students myself, and I got to tell you, it's tremendously rewarding for me. But also the LSO and OPA must be in constant contact with each other. And the Ontario Paralegal Association is an official Law Society stakeholder. I know I have invited George to the Paralegal Standing Committee to address my committee so that he could, you know, voice the issues that are at hand that are of concern for the paralegal community. And bear in mind, the Law Society's mandate is of the public interest, and legal organizations like the Ontario Paralegal Association are really there for you to voice, be your advocate when it comes to dealing with the government, dealing with the regulator like the Law Society. But with that being said, the Law Society is also very committed to enhancing and promoting the paralegal profession, and also a great resource for you. Treasurer Donnelly had mentioned earlier that our website is just piled with resources. Plus we have the helpline as well. So these are the things that the Ontario Paralegal Association, the Law Society have to do both individually and collectively to ensure our students are well connected and relevant to them. Those are my comments, James.
Thank you, Robert. Ms. Donnelly?
So I'll just pick up on some of the things that Robert said, and I'm going to be brief. What I look at this is, I said it earlier, it's about building connections. And the Law Society needs to build a connection to you, to each of you, and particularly to paralegal students. So as Robert said, I've been going out to the paralegal colleges since last December, and I'm going out to another one this week, actually, and it's been fantastic for me to go and to present. It takes about an hour. So if anybody's interested in me coming to their organization or to a group to talk to you, I'm happy to do that, where I spend about an hour talking about the programs and the resources that the Law Society has. Because it's important that each of you, either as a licensee or a student of the Law Society, understand what our role is. As Robert said, we're a legal regulator. So what's our role, and how can we support you? Because the Law Society doesn't want you just to survive in your practice. We want you to thrive. And what are the ways in which we can help you? I encourage you to go to your source on the Law Society website and to look at some of the programs we have. We offer a full suite of programs, from offering mental health support through the Member Assistance Program, which is available to all licensees, paralegal and law students, and eligible family members. It's free, it's confidential, and if you need help with mental health issues, with addictions, or support in your family life financially, in terms of counseling and things like that, reach out to the Member Assistance Program. It's myassistplan.com. We have Discrimination and Harassment Counsel. If you've witnessed or experienced discrimination or harassment by a lawyer or a paralegal or a student member of the Law Society, I briefly refer to the Practice Management Helpline. And when I close, I will give you more details about the Coach Advisor Network. So those are just some of the things that we have. Stay connected to us. Watch our board meeting, which is called Convocation. You can watch it live, watch a webcast, read the transcript. We offer accredited continuing professional development programs approximately once a month. Our Equity Legal Education Series, it's accredited for EDI, CPD, or continuing professional development, and they're free, they're online, and they're really important conversations. So those are just some of the ways in which you can stay connected to us. But it's really important to build lifelong connections between us as the legal regulator and between you as the licensee.
Thank you, Ms. Donnelly. What do you see the role of paralegals in the access to justice context, specifically dealing with advocacy? And throw that one over to Naomi.
Sorry. I'm just reviewing the question.
Mm-hmm.
Can you repeat it?
Yeah. What role do you see paralegals helping or contributing in the access to justice focus that the law society and the provincial government is having right now?
Right. So, when you're just starting out and you are excited to offer legal services, oftentimes we as legal professionals underestimate the value of collaboration. So I previously worked in-house as legal counsel to Hydro One, and I went on my own. And once, obviously, the legal team in-house and all of the experts that were at disposal at Hydro One, the value of them became more omnipresent when I was out on my own. I was like, okay, great. I need to start building connections with other practitioners similar to my practice. So I would recommend, if you're, the role of the paralegal in creating access to justice is to reach out to other professionals where you can either supplement some of the legal services that they're providing or contribute to some of the legal services that they're providing. So if you know of a legal counsel that participates in judicial reviews or does appeals to divisional court, and you have a strong practice where some of your decisions are likely to be appealed, or there is appealable decisions that come across your plate, build those relationships earlier on, because today, obviously the rules limit what you can do, but you can focus on how you can build your streamline, your income and establishing yourself as an advocate and making your resources available. I often employ students in my legal practice, from paralegals to law students. And one of the feedback that I constantly give them is that when you're working with legal counsel, your goal is to provide value to the client, right? And to provide competent services to the client, and put your relationship in access to justice to that. If you have to, adjust the kind of services that you're providing, that's okay, and you can do that, and that's something that you should be doing. I recommend, strongly urge you to do that, to reassess your practice on a quarterly basis. What's not bringing value? What's clogging up your time? What's interfering, with your practices? And how can you streamline your processes and how you onboard clients and how you do client intake to create access to justice in that way? I think those are all the thoughts that I have for right now. But generally, don't limit yourself. Reach out to other clients, practitioners. If you're not going to practice in a certain area, at least you can build those connections so that you can refer people out.
Excellent, thank you. Ted, you have a few thoughts?
Yes, I'm kind of looking at this from a different perspective as is the information here that, the paralegal cohort is somewhat different from the lawyer cohort. The information that I have is about almost 39% of paralegals, as opposed to 22% of lawyers, are racialized. And I see that in my classes. There are a lot of people who can't.
Sorry, Ted, I think you're on the next question. I'm trying to asking about the role of paralegals and access to justice. Was that the topic you were talking about?
Yes.
Okay, sorry, just make sure we're clear.
Yeah, but on the question of access to justice, we have I don't know, kind of a gray zone as to what that services that paralegals can provide. And until that gray zone is cleared up, I think that we have to work on that. There has to be more information out there to the public about what paralegals are and what they can do. So they're there, but I just don't think that the amount of work that they get is commensurate with what they could do. Anyway, that's what I'm thinking about this.
All right. Okay, so segueing into the next question, I'm going to ask Naomi to start with this one. Like Ted just mentioned, 38%, almost 39% of paralegals and 22.5% of lawyers are deemed racialized. What are the challenges now and in the future that you think paralegals from those backgrounds could face while developing their advocacy skills?
Yeah, so as an Indigenous woman lawyer, I experience a lot of, sadly to say, questionable conduct from other legal professionals, in particularly male lawyers. It doesn't matter if they're racialized or not. And I have developed a strong network of senior practitioners and also practitioners around my year of call who are dealing with similar issues as me or who have dealt with similar issues. And senior practitioners, just to have a sort of a network where I can receive insight into ethical issues that arise. And as has been repeated before, what is to consult the practice management helpline. I use that very frequently to be in fact, and I strongly urge any legal practitioner, paralegal or lawyer to maintain that healthy relationship with your regulator. And when you have a number of other practitioners that you can turn to, lawyer or paralegal, because I have both in my networks, you don't feel limited or trapped, and you can get a diverse range of experiences. The reason why I have friends or a network of similar year of call around my year of call is that, I can just have a frank conversation with them about, like, have you felt this way or anxious before? A senior practitioner may not remember how they felt when they first started out, or maybe they do, or maybe the issue may not be as relatable to them as, their issues that they're dealing with are significantly different. And with that in mind, you will have this sense of confidence, and you will build your own practice and your own processes in terms of when you're challenged in these particular moments. And also, if I can make a strong recommendation to somebody who finds themselves in similar shoes, that you may have to consider reporting the other practitioner to the Law Society, and to make the rules of professional conduct your friend, because in any particularly troubling or difficult situation, the guidance that those rules offer will help you in the end. And you want to uphold and protect the integrity of the legal profession, as well as encourage the respect for the administration of justice.
Excellent. Thank you very much for that. Ted, a few thoughts on this question specifically? I think you're still muted.
I had 3 or 4, I think 4 articling students who were from racialized communities. One was from Vietnam, one was from South Africa, but who came from Uganda, and another one was from Trinidad. I had an experience when I was a young person. I got to go to Trinidad for a whole summer, and coming from Edmonton, which is the Great White North, so to speak, back in the late 1960s, it was an eye-opening proposition. One of the things that I see is that lawyers and paralegals who are connected with a particular community, I think that there's a sort of a perception in the public mind that those people are there for that community. And I think sometimes it causes the newer members, before they get a proper practice going, to be seen in that light. And so I think that there needs to be more, I don't know what kind of support, but some kind of support for making it known that persons who are in a particular group, they've got the law for everybody, not just for that group. And I think that because the public doesn't really know what paralegals are about, there's an underlying credibility question that needs to be addressed. But I know that the students at trials have a kind of very positive reception there, and have told me, I'm talking about racialized students, have told me how grateful they are that our organization is, really takes them under our wing and gives them the support they need. And I think that's something that all lawyers and all paralegals need to do.
Thanks, Ted. Teresa?
Thank you. I just want to follow up on something that Naomi said, really, really important. She talked about you may have to do something about it. You may have to complain. And she referenced the rules of professional conduct in a complaint to the Law Society. I just want to talk very briefly about the Discrimination and Harassment Council. So if you've witnessed or experienced discrimination or harassment on human rights grounds by a lawyer, a paralegal, or a student member of the Law Society, anyone can access this program. It is available to members of the public, to lawyers, to paralegals, to students, anyone. It's free of charge. The Law Society funds it. They have their own website, which is dhcouncil.on.ca. I encourage you to look at it, because what it is it's a safe space. It gives you an opportunity, if you're witnessing or experiencing discrimination or harassment on human rights grounds, to go to speak to lawyers who are experts in this area of law, to understand what your options are, from maybe something in human rights to maybe doing nothing, maybe strategies to help you deal with what's going on, to maybe it's a criminal complaint, maybe it's a complaint to the Professional Regulation Department at the Law Society. All different options available to help you, someone to talk to. So I really encourage you to think about this. And again, know you're not alone, that there are supports available for you.
That's excellent reference. And while I have you and Robert out, Ms. Donnelly, I'm just going to go right to the last question. We're kind of cutting it fine here. This is a topic dear to me. Now, where do you see paralegals working within the family law spectrum? And do you have a time frame on Ms. Donnelly? I'll let you answer first.
Okay, thank you. So you will know, and the students might not know, I saw a question in the notes or the question and answer of the chat that asked about family law. Exactly a year ago, Robert, we launched that call for consultation on the Family Legal Services Provider proposed license. So that was for paralegals to play a role in family law. That closed at the end of November. After that, we did some targeted surveys to continue to gather information and to help us as we worked through the submissions. We received lots of submissions in the call for consultation. This is all before the Access to Justice Committee now, that they're continuing to work through it. We have one more board meeting before we take a break for the summer. So that board meeting is in June, where then we don't have a full convocation in July or August. So hoping that we're coming back at this in the fall with some information or report from the Access to Justice Committee. Robert is a member of that committee. That's not the one he chairs. He chairs the Paralegal Standing Committee, but he is a member of the Access to Justice Committee. Robert, anything to add to that?
Yeah, that pretty much sums it up. I mean, we obviously, in our surveys, we got responses in from, for the call for consultation, we got responses in from judiciary, lawyers, paralegals, educator providers, but most importantly, the public, the end users. So the surveys also were sent out to family law lawyers, paralegals, and again to end users. Because, I mean, obviously we have to take all different factors into consideration when coming up with a plan and a scope. So that's where we're at now. We're deep into reviewing all of the responses that we've got from the survey. What is it all telling us? And we are going to sit on that and think about it, ruminate over it over the summer, and then come back in the fall, and hopefully we can start up again, and then hopefully have something maybe by the 2022, hopefully. But no promises. The other thing I just wanted to say about the DHC, James, that the treasurer was talking about is we now have out to hire a paralegal for that because we think it was important. And I belong to that committee, which is called the EAC, which is the Equity and Indigenous Advisory Committee. And we thought it was important to have a paralegal play that role for the Discrimination Council, Discrimination Harassment Council, because we want to make it comfortable for everybody to reach out and to complain if necessary, as Naomi had mentioned.
Excellent. I want to thank everybody. This ends the moderated portion of the evening. We have some questions and answers that Kalisa and Jasmine are going to put to various people on the panel. I just want to again express our gratitude for all of you taking the time out of your evening, and for some of us the importance of the events happening at Scotiabank Arena right now. Just thank you so much for providing so much wonderful information and good tips and good things that we need as students moving forward into our careers. And so I'm just going to turn it over to the ladies. I don't know which one of them is asking the first question. I'll just say thank you very much and have a good evening, everybody.
Hi, everyone. Thank you so much, James. Thank you so much to everyone for joining us here today, and a special thanks to all the panelists for their time and all the great information that's been shared thus far. My name is Jasmine Tutt, and I, along with Kalisa Reyes, will be asking the panelists a few of the pre-registration questions. The first question is from Jaspreet, and she asks, what advice would you give newbies who are just now entering the profession?
Okay, are you gonna, you gonna start with that, Robert?
Well, I was going to say, when I was new, believe it or not, I can remember that. I kept my ears open. The best advice I could give you is to surround yourself by senior lawyers or senior paralegals who can, and you can just sit and listen. Quite often, I found myself in the midst of great debates between paralegals and lawyers about various different issues. And sit in courtrooms and watch. I mean, you can sit, like Stephanie had mentioned earlier about sitting in courtrooms to learn different advocacy styles. So there's that, there's how to present evidence, there's when to make submissions, who gets to go first, are you calling, if you don't call it your client, who makes the closing submission. There's so much that you can just digest by keeping your eyes and ears open, and surround yourself with great mentorship. As students, you'll all be given placement positions that require a minimum of 120 hours. Some colleges bump it up to 140 or 160, but there's nothing to prevent you from asking to stay on even longer. I've had many of my students want to stay longer because at that 120 hour, 140 hour moment, they are just starting to digest. And now it's the implementation that they would like to try to do. And so that's where staying on a little bit longer would be a great asset for anybody.
So I'm going to use this chance now to talk about the Coach Advisor Network. So my advice for newbies is to sign up with the Law Society's Coach and Advisor Network. And I want to take some time to talk to you about this program. It is free. It is an opportunity for you to develop your skills and to ask questions. So it is, the Coach Advisor Network is, there are people who are peers, experienced lawyers and paralegals who provide coaching and provide advising to people who need help. It's not just for newbies. It's not just for new licensees. It's throughout your career. This Coach Advisor Network is available to you. Why do I say that you should join it? For me, I'm a huge advocate of lifelong learning. I always wanted to be the best I could be as a lawyer, and I always tried to hone my skills. And then when I look at the Coach Advisor Network that the Law Society offers, I think you should all at any stage, reach out and connect with it and sign up. If you're experienced, sign up as a coach or an advisor. If you want some help, even just to refresh things, sign up to get some assistance. What's the difference? They're two different things. I'm going to start with advising, actually. What is advising? Advising means you call up and you get matched with someone who is more experienced, and they will help you. So if you have a file-specific question, so you have this file, you just don't know the answer to it, you don't know what you should do on it, you can call the Coach Advisor Network and get matched up with an advisor who will spend 30 minutes with you, giving you guidance on a substantive or procedural matter. Like it's just so good. But what about coaching? This whole thing is about advocacy, and it's about how do you develop your skills? Well, what better way to develop your skills than to spend it with somebody who has those skills? So this is what coaching is. So coaching will begin with an 1.5-hour session. So you're getting a one-on-one 1.5 hours with someone who's got a skilled legal practitioner, a lawyer or a paralegal. And then it's followed up by 30-minute sessions in alternating weeks for an approximately a 3-month commitment. So you get the 1.5 hours and then you get the 30-minute sessions, but spanning 3 months. And what is it for? It's to help you develop a specific skill or a best practice. So practice management, best practice, exactly what you need to help. So what I'm thinking of is I'm a prosecutor. I was a courtroom lawyer my whole career. What would I want to know more about? I'd want to know about cross-examination skills. How can I be the best cross-examiner I can be? I'd want to know about examination skills, examination in chief. How do I elicit the story or the evidence or the facts? What's the best way to get that out of my witness? And cross-examination, because I want to know is how do I attack or discredit the other witness on the other side? I'd want to practice my public speaking skills. I'd want to increase my confidence in the hearing room. I'd want to develop my style. Stephanie said, go watch, learn from other people's styles. And you can also learn things like how to effectively manage your files. So all those things, cross-examination, public speaking, increasing your confidence, developing your own style of communication, those are all things that a coach can help you with. So I really stress this to you. We looked at numbers to see how many paralegals are using this. In 2019, 15% of the Coach Advisor networks involved paralegals. In 2020, that dropped by 1% to 14%. However, I'm so pleased to tell you at the end of May, we're already at 13%. And for paralegals using the Coach and Advisor network. So really encourage you as a newbie, reach out to the Coach Advisor Network. Why wouldn't you? It's free. It's going to develop your skills. And it just confirms what we're talking to you about tonight is building connections, building that network of support to help you become better at what you're doing. So that's my pitch for you as a new paralegal or as a new lawyer.
Thank you so much. So our second question comes from Jillian, who would like to know what you believe are the best practices for advocacy over Zoom, specifically regarding virtual trials, as some details will be different compared to in-person trials.
So I'm going to I think that should be something maybe George, that we turn to you, George, to assist us with that. Or Robert? Oh, there's George. You're just on mute there, George.
Sorry. Could I get the question again, please?
Best practices over Zoom. George, how do we effectively use that? And then I'm going to go to you, Robert.
We're still in the process of implementing best practices with Zoom. What the OPA has done is entered into a partnership relationship with Zoom, where we've become a reseller of the Zoom platform, and we are able to offer the Zoom platform at the price that the OPA decide is a good fit for our members. And one of the reasons we've decided to do that is more and more courts are opening and utilizing that platform. And a lot of our members and non-members are utilizing the free Zoom account. And we believe that sooner or later they'll have problems down the line, because if you're doing a long trial, these trial accounts will shut down after 45 minutes. So we decided that offering Zoom to our members will help them to be able to stay in these hearing rooms. We've also brought in, as part of the package, Zoom training to explain to our members how to maneuver in the software, how to go into some of the rollout rooms, and be able also to assist the trier of fact or the court when they run into a problem. And so we believe that we need to upgrade and bring ourselves to the point where we become expert at using the platform. I don't think we're there as yet, but we are working towards that. And so that's pretty much, I myself have difficulties at times. So I'm waiting for that training, and I believe that we will get to the point where we can run around the software, and hopefully very soon. We'll be launching that very soon.
Robert, do you have anything to add?
Yeah, I'm going to just give some pretty basic practice tips for advocacy. One is, and you'll have to play around with the Zoom platform yourself, but I like to do a split screen. So one of my functions is as Treasurer Donnelly has said, is I'm chair of the Paralegal Standing Committee. So not only am I having to make speeches and so forth and submissions, as you will in your advocacy, so you would want to make sure your material that you're also relying on is available to be seen. So I always do a split screen. So right now while we're doing this presentation, I had the questions that I knew I was going to be asked on the right-hand side, and then the screen showing, who my fellow panelists were on the other side. And because ultimately you want to be able to look straight into the camera. I mean, and you want to be in the center of the picture. As you can see me in the center of the frame. The background, you want it to be as neutral as possible. The background here, mine is some of my Italian heritage. It's some old pictures, but you want to keep it as plain as possible. You want to avoid having anything in the screen that may be distracting. Somebody gave me this great tip one time and said, don't have a bottled water with you, because there might be some environmentalists that are on the panel that you're speaking to or what have you, and you don't want to be seen with a bottled water. So have it, with a glass or something of that nature. And even though it's Zoom, you still have to be properly attired. So, business attire is always very appropriate. And you want to make sure for data purposes and bandwidth that you're, in my case, my teenage son isn't gaming while I'm doing an important presentation, because the last thing you want to do is lose connection. Obviously, we're working out all of the little bugs that with modern technology, and that's where you as students you're going to be growing with the Zoom platform or whatever video conferencing platform. So I'm expecting big things from you guys. But main things that we've been told, and I've been told as an adjudicator, one of my functions at the Law Society is I'm an adjudicator, and we were told, to ensure and make sure everybody knows that if your head is down, that you are making notes. So you may even want to mention that, Your Worship, Your Honor, if I'm not looking in the screen, I'm taking, notes. So if my head is down, things of that nature, because we're all new to this, right? And we don't want to come across as looking disrespectful if you're looking away or you're looking down, because it's all very important aspects to being an advocate, is looking at the parties that you're addressing squarely, being in the center of the screen. As I said, minimal background, minimal interference. Don't have anything that's distracting on your screen as well. Things like that. Just very simple practice tips. So that's what I would add. Thanks, Teresa.
Great. And I just would say to everyone as well, last week, there was a release of a document called Best Practices for Remote Hearings, second edition. It's an Ontario document done in collaboration with the Ontario Bar Association and FOLA and the Advocate Society. And it's a PDF, and it's available on the FOLA website. So that's the Federation of Law Associations, Federation of Ontario Law Associations. So it's fola.ca/courts, and you'll see it in a whole list of documents. So I think that that's worth a read as well. And George, that might be of assistance too, as you're working through your work for the OPA. I have it, George, in a PDF format, so I'll email it to you as well. So that's that question. Jasmine, do we have another one? Or Calissa, do we have another question?
Yes, thank you so much, Teresa. So the next question is from Andrea, who asks, will the elitism that has plagued law for centuries begin to dissolve in a digital advocacy era?
Okay, so I don't know, George or Robert, maybe we'll start with you, George. Do you want to think about that one?
That is a great question. And I don't have a great answer for it. I think if anyone that will change this situation in the future, I think it's you guys that are coming out, that you have the ability to transform this profession, this legal profession, into something that we've never seen before. So many of you are so savvy with technology, and this couldn't have happened at a better time for you guys coming into the profession. I think that you guys are going to show us that you may not have the legal skills, but at this point, but you have the technological skills to move around, and we'll be impressed.
So I'll take a stab at that one, Teresa. So I'm just going to give a little story that kind of tells you how the elitist gets broken down. So I was first elected as a bencher in 2010, March 2010. And it was the first time a paralegal were elected as benchers at the Law Society, which was, dominated by very prominent leaders of the legal profession. And here I was, I was younger back then. So what was that, 11, 12 years ago. When I first got there, I wasn't really well received. I was told, for example, that there wasn't a locker for me. Convocation, which is our board meeting, I wasn't permitted to speak. And now look at me, 12 years later, they can't shut me up. And I'm the chair of one of the standing committees. I mean, walls are broken down all the time. Barriers are broken down. Some of the great work that we have done that we've mentioned earlier is the Challenges Facing Racialized Licensee Report, the Indigenous Review Panel, things about equity, inclusion, diversity that we really have done. And it's not limited to the Law Society. I mean, organizations like the Ontario Paralegal Association are front runners in this quest to break down these types of barriers so that there is equality, so the elitists don't run the entire story as the question poses. And I think having a voice, and belonging to associations that advocate for you, that advocate for equality is vitally important. There is an organization called RODA, which is the Roundtable of Diversity Associations, and their quest is to ensure that there's equality amongst all of us. And I think supporting those types of organizations through the Ontario Paralegal Association is a great way to ensure that we are all playing on a balanced field.
That's great. Kalissa or Jasmine, we have a little bit of time left. Is there one more question that we can sneak in the 6 minutes that we have left?
There is. Our fourth and final question is from Liz, who would like to know if, to your knowledge.
Sorry, you put yourself on mute there.
Oh,
That's
no,
okay.
I'm so sorry.
That's okay.
So our fourth and final question is from Liz, who would like to know if, to your knowledge, there are any updates to advocacy for 2021.
Okay. Robert, do you want to start with that one?
So I guess the biggest thing for 2021 is technology, right? I mean, we've mentioned it throughout today's CPD that this is an opportunity. We're all learning a new technology. We're all learning new ways to advocate through technology. This might also allow us to hone our written skills, because we may want to put in written submissions instead. We may want to have agreed statement of facts, things like that weren't as common before. These are a lot of administrative law matters are going to ASF, so agreed statement of facts, to really focus in on the key issues at a hearing. And so those would be probably the two things that I think is more collaborative work with the other side, and also taking advantage of the new technology that's at our disposal.
George, do you have anything to add to that?
No, I love Rob's answer. I'll just stick with Rob's answer.
Okay. Okay, Ted, I saw you turn your camera on there. Do you have anything just briefly?
I just want to say the bigger they are, the harder they fall. I went up against a big time firm with a big time bank, and I brought a motion to have their appeal struck out as frivolous and vexatious, which it was. You can do that too. It doesn't matter. They think they're the giants. Forget it. Just stand up for yourself.
Okay. I think, are those all the questions then, Jasmine? I'm just thinking we have 3 minutes left. So I just thought I'd check in. I think you said that was all of the ones for Kalissa. Okay.
Ready. So
yeah, Jasmine, sorry, or Leo.
Well, I think those are the questions that we have so far. First of all, before we close, I would like to ask you to make the closing remarks on behalf of all the panelists and the LSO. And again, I would like to thank each of our attendees. Thank you, Teresa, and please take away.
Okay, I'm going to be brief because I know we have 2 minutes left. We've kept you when we spend a lot of time on Zoom, and they can be really long days now, so I'm not going to go over. And I also know there's a really important hockey game on right now. So what I will say is thanks to each of you for joining us. It's really important to have these conversations and to learn from each other. And as I said, build our communities of support and knowledge. Thanks to each of the panelists for your insights. I think we've provided lots of tips and practical strategies to help new paralegals and lawyers and those who are already in their practice to help them develop their skills. So thank you for that. And I'd like to really extend my congratulations personally and as the treasurer To the Student Committee of the Ontario Paralegal Association. You said at the outset that this was your first foray into continuing professional development, or your first learning event. And I just am so pleased at how this turned out. I know you spent a great deal of time working on it. I got all the materials that you sent. And when we talk about preparation, each of you did it. You spent so much time to deliver what I think has just been a great program. Thank you so much. And to those who are already members, this is accredited for continuing professional development hours. So update your portal. Thank you so much on behalf of all the panelists. It's 7:59, so I'm going to wrap up now by saying thank you, merci, miigwech.
And again, I would like to thank the LSO, and on behalf of the OPA and Trials College Healthcare Technology, we would like to thank you, all the panelists, Ms. Donnelly, George, Robert, Naomi, Ted, and Stephanie, for taking the time away from your families this evening and join us, and for sharing your expertise, because that's important. And you know, it's crucial for the OPA membership and for the invited guests. Please note, as the treasurer mentioned, that this program is accredited by the Law Society for 1 hour professionalism content and 15 minutes of EDI professionalism. Okay, and then please, Scott, continue.
Thanks, Leo. I'll be very quick. I just wanted to make sure that we note that only active OPA members are eligible to receive their certification for their annual CPD requirement. Please visit our Learning and Professional Development portal at theopau.ca for all the latest news and announcements from the Student Committee and the Education Committee. Just a reminder to please take a few moments and complete our feedback survey so that you can help us improve our service delivery to the membership. This concludes this evening's OPA CPD series in partnership with Trios College presentation on the panel discussion on advocacy. Thank you to all our members and the guests for their participation. Good night, everyone. Stay safe. Go Leafs, go.